Welcome to today's program titled Virtual Coffee on Virtual I-9s, Immigration Compliance in the Wake of COVID-19. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and PowerPoint presentation will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to John. John, you may begin.
Thank you. Good morning, everyone. This is John Basilisi with the U.S. Chamber of Commerce. I want to thank you all for taking time out of your busy days to be on this webinar today to talk about the virtual I-9 process, which over the past couple of weeks has been it's been trying in terms of trying to get the Immigration and Customs Enforcement and USCIS to understand how important this is for companies that are onboarding during this time when COVID-19 is pushing a lot of your companies to move to telework operations. But the guidance that was issued has been helpful to a certain extent. It's lacking in others, but we are doing our best to make sure that we are moving forward and making sure that the business community's interests are taken care of. Before we get to going on the substance of this webinar, we are going to be taking a couple of poll questions. The first question is your company continuing to onboard and or hire new employees during the COVID-19 process? And the answers are no, we are in a hiring freeze, yes, we are onboarding new hires, and yes, we are experiencing a hiring surge. The other question that's in the poll is, have you used the authorized representative model prior to COVID-19 pandemic? Those are two questions that we will be asking today. Another thing that I want to make note of before we begin the substance of this is Seyfarth Shaw has a COVID-19 resource center, and if you'd like to sign up for their daily updates, it's there on the slide, www.seyfarth.com/COVID-19. And the U.S. Chamber of Commerce also has various resources for all types of businesses that are available. And that's at uschamber.com/coronavirus. We also have a legal disclaimer, as it should be known to all of you. The material in here is not to be construed as legal advice or a legal opinion. This is for general information purposes only. So if you do have further questions on this, you should be asking a lawyer that can help you with your unique facts and circumstances. Moving forward, the objectives of our webinar that we have here is we're going to give the participants a background on the state of immigration compliance with regard to the I-9, overview of the I-9 rule, and the eventual guidance that was issued, I think about a week and a half ago at this date, when they relaxed the in-person requirement for certain employers that are teleworking. There are various options for compliance during COVID-19 for individual companies to choose how to do the I-9. There are reasonable interpretations of how this flexibility is to be dealt with, and also the interplay between the I-9 and what companies can do to help show the federal government that they're doing everything they can to verify their workers by also utilizing the E-Verify program. And last, certainly not least, there will be some discussion on worksite enforcement post-COVID-19. Yours truly here, John Basilisi, is going to be speaking with Dawn Laurie, who is the Immigration Senior Counsel at Seyfarth Shaw Washington, D.C. office, as well as Julie Myers-Wood, who is the Chief Executive Officer of Guidepost Solutions, and also used to run ICE back in the day under George W. Bush's administration. Moving into the meat of the presentation, we're talking about worksite enforcement during COVID-19. And I'm going to kick it off to Julie. Julie, take it away.
Hey, thank you so much, John, and thank you so much to everyone who's joining. These are really extraordinary times. We are all kind of working through these challenges, and ICE is in the same boat. And so I think they have given some guidance that they are really focusing on criminal alien arrest and continuing its practice of not making any arrests at hospitals or other sensitive locations, but it's a weird time. So I think we can see that the agency is still trying to absorb how much focus should they have with respect to worksite enforcement, if at all. That's not to say anyone can put off doing the I-9s or doing them well, because when this is over, and it will be over, we will all be, ICE is going to get back to business. And at that time, they'll be thinking about, you know, what problems are there in workforces, are there unauthorized workers, and who let these requirements slide. Dawn, is that your impression of what ICE is doing and thinking about at this point?
Absolutely. I think that they were very reasonable in the guidance, and I think that as a result, there are already people that are thinking about, what's going to happen afterwards. I mean, at the end of the day, we're dealing with employers across the board, some of which are being forced to close out, to shut down operations. They're modifying their businesses in ways that we never thought possible, and it's really, as you said, it's just unprecedented. So as a result, I think, we all need to be reasonable, and we don't need to be greedy, because if we are greedy, it's going to backfire. So so today we're going to be talking about all these things, and we're going to be, following what ICE is going to be doing, and I guess anticipating, the directives that are really going to be coming, frankly, from the White House. And I think we need to be careful about that and make sure that we don't overstep.
That's a great summation of where the current state of play is. Dawn, Julie, for the folks on the call that are probably, government relations representatives, things like that, and people that I work with generally here in D.C., can you give us all an overview of the current I-9 rules?
Sure, I can get started on that. So the I-9 rules, first of all, in terms of background, the Form I-9 is the vehicle in which employers since 1986 have been asked to verify somebody's identity as well as their work eligibility. The way that employers do that is by completing the Form I-9. So the rules, and the ones that we need to keep an eye on today, Section 1 needs to be completed by the employee. That should be done on or before their first day of work for pay. We call it the date of hire, again, or the date of work for pay. So somebody may be hired, several weeks in advance, but they may not start until next Monday. The controlling date would be that Monday date. There has to be an offer and acceptance if you're going to do it before the Monday date that we just spoke about. The employee themselves would complete Section 1, although there is a provision for a preparer or translator to assist. And if they do assist, they will need to make sure that they complete the preparer translator box that's on Section 1. Section 2 needs to be completed by the employer or their authorized representative. And the timing for that is on or before the third day of work for pay, again, the date of hire. At that point in time, this is a joint venture, if you will. The employee comes in and they need to present unexpired original documents. And again, we're going to be verifying the identity and their work authorization. The documents that can be presented are on the list of acceptable documents, which are found on the third page of the Form I-9. And by the way, folks, there is a new Form I-9 that all employers should be using now, but must be using by the 1st of May. So if you're not using the new Form I-9, please make sure that your workforce is transitioning over. So again, that information is going to be completed on Form I-9. When Section 2 is completed, the employee should be in front of the individual. You should be looking at the photograph that is either in the information that's either in List A or in the List B section. And you're going to be verifying that this is the person that's presenting the documents. And then you're also going to be recording their work eligibility. So you're either going to be putting a List A document down or a List B and C document. We're proving the identity as well as the work authorization. The rule right now, pursuant to the regulations, is that the employer should be physically reviewing the documents in person. And that's kind of where things are, where the crux of the problem is right now, where in certain situations it's impossible to actually review. Don't forget, regardless of whether or not you were doing this before, you're taking care of this now, the employees have their choice of documents in which to present, right? They have their choice. They have the list. They can go through that list. Section 3 is not completed by everybody. It's only completed in the instance where there's a work authorization that's expiring, generally for an alien authorized to work. And the timing for that is it has to be completed before the work authorization expires. So those are the basics for Section 1, 2, and 3.
Thank you, Dawn. So the relaxation of the in-person requirement, I know that you, me, Julie, many others that are on this webinar were happy to see that ICE and USCIS and DHS-HQ signed off on issuing guidance that would help let companies verify their workers in a more normal, not necessarily normal, in a fashion that allows them to be able to meet their I-9 requirements without having to do the in-person requirements. So any color that you or Julie want to add on that?
Yeah, sure. We worked really hard in the days after we realized that COVID-19 was going to really have an effect on companies across the United States. So there were various groups, including the Chamber, including AILA. I know we contacted everyone we possibly could. Julie's team did as well. And of course, congressional leadership, as well as offices, were working with Immigration and Customs Enforcement to try to get some sort of guidance and for some sort of recognizing of the fact that it may not be possible to actually see individuals in person. So on the 20th of March, ICE posted this guidance that, basically acknowledged that because of social distancing and issues with physical proximity, it may not always be possible to conduct the I-9 process in person. So they provided this guidance that kind of, we're going to discuss it. We're going to take it by chunks that went through what needs to be done and what the timeline is for it.
And this is a really big deal. I just want to add, this is a really big deal, this guidance being issued. It's been a problem for a long time to have this physical requirement, physically reviewing the documents. And of course, it comes from Congress and the executive branch putting the burden on the employer, right, to be the document detective. So it's a huge deal now to have some options in certain circumstances. If employers are successful in doing this right, and ICE can see that employers do this right, I think there's a very strong argument to try to push to make something like this more permanent and not keep us, back in the early 20th century, moving to really the way companies are working all the time now, more remotely.
Yeah, and I think it's a great point to bring up, because I do think that the government's going to be watching this carefully. I mean, the fact is that we do things virtually all the time now. We are a global society, and the ability for individuals to use electronic signatures, to do things via video, has improved tremendously, especially in the past 2 to 3 years. So it seems reasonable that the time is ripe to go back and to have this amended, whether it's, by regulation or in some other manner. Again, like you said, though, we need to, this is our opportunity as employers, again, not to take advantage of this and to do it correctly. And if we do, I think that there is going to be the ability to take this dialogue to the right people and to push this through. John, is this something your members is of interest to your members, or is it rhetorical?
Yes. No, this is not. That is real. And the one thing that I think is interesting, that if you look at the historical view on the in-person document review, you have just the ability to do things via webcam. Not only can you look with a much clearer picture of an individual holding his or her ID next to his or her head, and you can see, all right, the picture there looks a lot like the individual is holding the ID. You can also take screenshots with your phone. Sometimes your tablet has cameras on them. You can capture this in real time. So you can see the person's holding an ID that looks real, and you can have 2 screenshots, one where they look at the front of the ID, another one is looking at the back. The ability for companies to be able to do this, it just makes sense. There's no reason why, given how technology has changed since 1986, why we can't do this. Are there any other points that you or Julie would like to add on the historical view on in-person doc review before we move on?
Well, I guess I would just... Go ahead. Sorry, I just would add, you can open up a bank account. Think of all the things you can do now, without doing in person. And so having this in-person requirement is an anomaly. And the in-person requirement, stemmed from IRCA, back in 1986, pre-E-Verify, pre-Basic Pilot. So there are a lot of different tools that are in place now. And so I really think this is the time to push, if this is successful, for a more permanent change that will ensure that there's an authorized workforce, but will adapt to modern times. So HR representatives aren't having to fly across the country to complete I-9s.
No, you were going to say something too? Okay.
Well, I was just going to remind everyone, it's just not 1986 any longer, and the technology is available. So, all right, yeah, let's talk about what our options are now.
I think you and Julie both make great points there, because it reminds me of when I bought my condo, because guess what? I didn't need to do things in person either. But moving forward, before we get to how companies should be looking at what their options are with I-9 verification in the post-COVID-19 world, let's look at we're going to make our poll results available to everyone that is here in the webinar. There are, if you look at the answers to the first question, we've got about 24% of the folks that are on the call said they're in a hiring freeze right now. The other 74% of people that answered this, they're onboarding new hires, and 3% of them, 3% of the folks that are on this call have said they're experiencing a hiring surge. As to whether companies have utilized the authorized representative model prior to the COVID-19 pandemic, you have a little over 1/3 saying yes, they have, a little over 2/3 saying no, they haven't. So moving forward to COVID-19 options, the big option that's been allowed by this guidance is using the virtual or remote verification. This is it's new. And Julie, Dawn, whoever wants to take this, go right ahead.
Yeah. So let's first of all, I want to just I want to go over there's really going to be four options. So let me set the stage here. So we're going to talk about the virtual, or now the way ICE wrote their guidance when they announced the flexibility and the requirements. They reference virtual or remote, right? The second way that Form I-9 can be completed is through an authorized representative, and we're going to call that the third party, or the friends and family, or the crowdsource model. That's the ability for somebody else other than an employee of the employer to complete it. The third way, which is, by the way, not approved by ICE and not recommended, I think, by anybody on this call, is just to suspend or delay the verification and to do it at a later time. And then the fourth, which I don't want everyone to forget about, which is, business as usual, no changes. You're just going to continue to do your I-9s as you would, because of the way your business is actually operating. So with that, we are going to talk about virtual remote first, and that is the flexibility, the relaxation, and the guidance that that Immigration and Customs Enforcement, Homeland Security Investigations provided us. And so, who qualifies? I mean, that's really the crux of the question. We're going to get into a little bit more later on, but on its face, it applies to employers and workplaces that are operating remotely. Now, the first thing I want to point out there is that there really isn't a blanket policy for a company. So we have many clients that, their corporate offices may be closed, but their manufacturing facilities are still very much open. So I think the way that we need to chunk this out is by looking at the different locations, because at the end of the day, I-9s would have been done at the specific locations, not, they may be done one way for corporate and another way for individuals in the field. So keep that in mind, that we're going to be talking about sites. The timing for this remote, it's by the way, it's a two-touch, right? So if you're going to choose virtual and remote, you're going to hear me be a little bit negative, because frankly, it's going to be more time-consuming at the end of the day. It's two times. Section 1 still, if you're doing it remotely, Section 1 still needs to be done on day 1, and Section 2, the first time around, is going to be done within the 3 days of hire. So if your person is onboarding today on a Monday, they should have already completed or should be completing Section 1. And then Section 3 has to be done by Thursday, because we don't count today. We start our 3 days tomorrow. So by Thursday, Section 2 will need to be completed. Now, how are we going to complete? What ICE says is that you have your choice. You can do it via video, or you can do it by fax or email. So they, in their guidance, they say video link, fax, or email. Now, video link, we're thinking Zoom. Everybody's doing Zoom. My kids are taking classes via Zoom. There's GoToMeetings. There's Chime. There's Google Meets. There's all different online platforms. What I thought was really interesting was the guidance that really allowed for fax or email. That surprised me a little. But what it told me, and Julie, I'm going to ask you about this. What it told me was that this was really meant to be just an initial review, and that really they're going to be looking to that secondary review. Julie, what did you think about the fax or email language that I put in?
Well, first, I don't know if everyone dug out their fax machines. You have to go back to 1986 to find a fax machine. But I think the fact that they allowed for fax and email and not just video is they're trying to give, frankly, some grace to employers who need a way to move forward during this time. There is obviously a lot of potential for fraud, particularly if there's not video, and I think the fact that they're allowing email and fax just shows that ICE wants to allow an initial touch, an initial way for the employers to move forward and be in partial compliance with kind of the rest of the story later on. I think it's good that they allowed, those three options. I think they potentially could have distinguished between video and email. Not sure whether fax has that much use in any event, but I think it's good that they gave different choices, because there are some employers that don't have video systems and are just kind of basically using email.
Yeah, totally agreed. And we'll talk about this. I think if you are using email, well, regardless of what you're using, you have to be really careful in terms of data security. So I know a lot of our companies are trying to get ensure that the encrypted email channels are being used, and they're having individuals be particularly careful with the documents. So they may be viewing something in one way, but they may be asking for an upload to be done another way by the individuals that are actually completing the Form I-9. So something definitely to think about. So in terms of
hey Dawn,
yes.
I was just going to say that the PII issue is a really great one, and we're seeing such an increase in potential hacks and cyber intrusions. And so now you have all these people working on their home networks and other things. And so it's really critical to be using encrypted systems or have other ways to protect that information coming over. You don't want to be the company that had a huge surge in hiring and then comes back later on and has to reveal, a massive hack and sharing of all these employees' data.
That's right. And again, just I think one more reason to really consider whether or not you have to use this virtual or remote option, which really, leads me to something else, which is, how are you completing the Form I-9s? Many of our companies are using electronic I-9 systems. And for those of you that know me, you know that I talk about electronic I-9s nonstop, and the fact that many, and this is for another webinar, but many of these systems that are on the market right now are actually not compliant. Even some of the big ones are just not compliant with the electronic I-9 regulations. But what we need to focus on right now, regardless of compliance, is whether or not they can actually handle these virtual and remote completions or third-party completions. So before you design a process or think about how you're going to do this, you need to make sure that your system will support it. So for example, if you want to do this virtually and you have people working from home, you need to make sure that they're able to get into the system and that you're using, for your electronic I-9s, that they actually have access to it. You also need to be able to make sure that there can be corrections made and updates made pursuant to the guidance that ICE has given. There are some systems that once you complete Section 1 or Section 2, you can't make any changes. You actually have to go back and complete a new I-9. And maybe that's not the end of the world, but you have to have a process that delineates this and actually describes it and talks about it. I think a lot of people are saying, can you just send me a policy? Send me a policy. And I say, well, there is no one-size-fits-all policy. And I'm not trying to be difficult. I'm really saying you have to look at what your process is right now and what type of support the systems or the way you're doing I-9s right now makes sense. So that even goes, for paper, right? So if you are completing it on paper, how are you physically going to get the paper that's a virtual, the person who's completing it virtually in their house? How are you going to get that? Are they going to be keeping it in some, secure place in their bedroom drawer? I don't know. So you got to think about all this, and certainly with the right amount of time and care, nothing's impossible. It can actually be drafted. So in terms of one of the things that we'd like to see that should go on the I-9s that are completed by someone remotely, you want to make sure that in Section 2, you actually annotate COVID-19. The government says, put the COVID-19 as the reason for the physical inspection delay. I'm actually advocating saying when the individual completes the Form I-9, they go on, they FaceTime, you're on your phone, they're on their phone. The person that's actually completing the I-9, I'm recommending you put COVID-19, you also add completed remotely in the additional information box. I think it'll be helpful later on because a lot of these audits and reviews are not going to be done next month or next year. They're going to be done several years, and all of this is going to be fuzzy, even to people that were around, during this disaster. So I think it's important to be careful. What ICE tells us in the guidance is that once normal business operations resume, the employee actually has to come in and have their documents re-verified in person. And then again, that 3-day period is going to come into play. So what they're saying is that when the national emergency is lifted, anybody who has used this remote onboarding will have 3 days. And by the way, if your company starts normal operations before this, also I think that they're going to count that as when the 3-day period starts. You're going to have to be careful to watch those timelines. So again, ensure that the COVID-19 at a minimum was entered in the additional information box. And by the way, you might be completing Section 3 if this is for re-verification for somebody who has documents that are expiring. Once that's
hey,
done,
Dawn, do you have any tips for employers so that they can reminder, should they use the same sort of tickler system that people use for Section 3? How can we make sure that they're going to be focused enough when normal business operations move forward to canvass all those employees and get them within the 3 days? It seems to me that this is a big area where there could be compliance gaps. And so what are you recommending now proactively for employers to be thinking about?
Yeah, so I think it depends. I mean, it's a huge gap, and it's part of the processes that we're writing into for anyone that we're working with on these processes. It's easy to say, right? It's very easy to say we're going to do this virtually and we're going to be done. I think if you're using an electronic system, find out what options you have. Will you be able to code these in such a way, whether it's the time period, whether it's the site, will you be able to run reports? Is there some sort of notation that you could make that you'll be able to pull these reports? If not, you have to have ownership of the system. There's got to be a person or a team, depending upon the size of your business, that owns this. Not only owns, whether or not you're virtual, you're remote, or using an authorized representative, there has to be an owner of this, and somebody who, when this is all said and done, is going to be able to go through and review to ensure that, number one, you have an I-9, and also that it's actually reviewed and correct. And Julie, I know that we're working with your company, Guidepost, for several of our clients, where you're helping us to reviews right now, like as things are happening, where there's a secondary review, whether because it's being done virtually or when we get to number 2, whether it's being done by an authorized representative. And I know you have systems in place that are going to be able to help track. So I think at the end of the day, I'm not going to dictate a business process, but it could be something as simple as a spreadsheet, right? Depending upon the number of your hires. For those companies that are larger and that are hiring in volume, I think it's going to be incumbent upon the owners of this to be looking at the timelines and the sites, and then being able to go back and ensure that these notations and this second touch is actually done. But again, it's going to depend. So in terms of this, we just talked about the ownership logistics and how it's being kept. The other thing you want to make sure is that you're actually uploading those copies. So in this process, whether or not you normally keep document copies, the government does want you to ensure that you're keeping these copies, and I think that's fair. It's reasonable, and I think it's a way that really a way to protect yourself. So what your virtual or remote completer has actually looked at. You have to have a process, especially with PII. Julie, do you have any recommendations on that with the documents? I don't know how you're recommending or what you're seeing in the field on that.
I mean, it really depends on company practices, size of company, and their kind of regular systems to keep track of those sort of things. But one thing I would say about keeping copies, if you weren't previously keeping copies, I think the reason that the government wants folks to keep copies is because no one's excused from the criminal requirements. And so if there's a problem, if there's a pattern and practice of illegal hiring or something else, later on, they're going to mine through that if worksite enforcement gets up and going again. So it's important that that you do a review of what's being done even before normal operations resume, so that you don't have any problems with potential individuals who don't have authorization trying to get into your workforce, since the labor market has tightened up so much.
Yeah, that's important. So we actually have a question, and I think it's a good question, whether or not, if you're doing this, the virtual, whether or not you're going to complete Section 3 when you're actually back to witness the documents. And I think there the answer is no. You're going to do it in Section 2. And that's why I was saying, depending upon what your system looks like, how are you going to go ahead and have this completed? I think for individuals, it's certainly going to be easier if the same person that looked at the documents the first time is the person that's looking at it the second time. But frankly speaking, for large companies, I don't think that's going to be the case. So what we've recommended is whoever is looking at the documents physically, you want to go ahead and you want to make sure that you are putting down, documents physically examined by Dawn Laurie on June 4th, 2020. That way it'll have the person who looked at it the second time. So basically what ICE is saying is that you just go ahead and put it in the additional information box. But what I see happening is somebody now coming in, 2 months from now with different documents. Maybe they gave you a passport virtually, but now, they lost their passport or it expired and they don't have it. They may bring in different documents. So at that point, I think that, we'd want to be careful and update and make a note in Section 2 what the new documents are and then who viewed them. Look, ICE put forth a policy, the best policy that they, what they thought was the best policy that they could in the time that they had. I don't think they thought about all these nuanced questions or what could happen or how we should be recording. So I think, these are things that we are going to need to think about, and there are going to be different scenarios that are coming up. But to answer that question, where things go, I think it should go in Section
2. Dawn, to follow up on that question, or your answer, I should say, as someone who has actually lost a passport, and if I had to get hired, I'd have to show new documents because I honestly don't know where I put it. Do we expect there to be any updated guidance or further clarity from USCIS or ICE or both on that point?
Yeah, that's a great question. So look, when we first went to USCIS with these questions and the timelines, because, during Hurricane Katrina and other natural disasters, we had seen guidance that, came out from USCIS, especially on E-Verify, because remember, USCIS, the verification division, owns the E-Verify system. But this time around, it was very clear that Immigration and Customs Enforcement were the owners of any enforcement and review or relaxation of these requirements. So to answer your question, no, I don't think that ICE is going to be giving us any more direction. I think that they've told us this is what the situation is. There are going to be some things that'll be looked at case by case later on. And frankly, I'm not sure we really want any more guidance from them. They've told us what's expected and how to do it. And then it's really going to be up to us, as everything else normally is, to put together, good policies. I do believe, and E-Verify has already told us that they're going to continue to issue additional, questions and answers. So I think we'll see an FAQ sometime later in this week.
Thank you, Dawn.
Just want to answer a couple other questions that I see right here. Individuals are asking about, how we're supposed to be looking at documents from a fraud perspective. And Julie, I'm gonna turn to you, but I will say that we always tell our clients, look, you're not document detectives, but that doesn't mean that when you're looking at things virtually or you're looking at copies, that you shouldn't be looking at them. The same way that you're looking at a document in person, you should be looking at virtually. So that would mean go to your M274, the employer handbook, look to see what regular documents look like. The residence cards, the green cards are available, driver's licenses. When the font is falling off the page or the photograph looks cut in, it just shouldn't be accepted. Julie, comments?
Sure, there are a lot of things that are evident from copies about fraud, so it's not always necessary to use a black light, like Dawn said. So I think what ICE is looking for is basic diligence on the part of employers at this time, and then bring into that your normal process. If you have a back-end review where you're doing some sort of internal audit or some sort of cross-check, now is a time, frankly, to increase that. And make sure that that you're looking for all the typical kind of fraud patterns in terms of sequential numbers, font falling off the page, any other inconsistencies. But I would not be concerned that you're not looking at things under black light. Frankly, ICE doesn't really recommend that in many instances anyways. It's dangerous for an employer to go too far in terms of document detectives. So I would say kind of use your best judgment and then try to make sure that you're thinking holistically about, are there any patterns of frauds that we should be seeing just from the numbers and just from reviews of either your spreadsheets or your electronic I-9 systems.
Yeah, that's great. And I think it's important to continue. Actually, just in terms of the timing, I don't know whether or not we'll see any additional guidance, but right now, DHS, they're going to continue to monitor the timeline. We heard the president speak yesterday. Maybe all this will be over in terms of the national emergency by the end of April, but we do need to take a look at whatever turns out to be the earlier. Right now, it's the May 19th date, which was 60 days from the guidance, or whenever the national emergency is terminated. And so again, everything will have to happen within 3 days. And for that reason alone, especially for those of you that have large work forces that you're hiring up now during a surge, I would be careful about using the virtual remote. I mean, it's great that it's there, especially for companies that are fully, fully remote. I know my company is, our law firm is closed. We have essential workers coming in, especially those in the immigration group that are pushing out, petitions, and thank you to all of them. But other than that, everyone's working from home. So if there is any hiring happening, it's not being done in the office. But I'm not recommending the virtual remote unless you can't use anything else. This timeline is going to be very, very tight. In terms of the memorialization, ICE has asked for the policy to be memorialized. So they want to know, what is your telework remote policy? What I'm suggesting is whatever your company has sent out, so if the CEO or the president or the owner of the company has said, this is what we're doing, go ahead and take that policy and then layer on what you're doing for I-9s. And you may have a hybrid policy. You may be using virtual only as a last resort and maybe doing it in person or with the authorized representative. So go ahead and memorialize this. It doesn't have to be anything fancy. I'm a big believer in less is more. So make it very, very general, and then ensure that it is put in. If you're using paper, you could identify it, to the extent that you can get it stapled to every I-9, that would be fantastic. But I think also having it in your binders with the dates that it applied and clearly available in the event of an ICE audit, I think that would be fair. For the electronic I-9 systems, I know some of them I've been asking if they can add information to the I-9 to see if there could be some attachment. If not, you're going to have to go back and maybe upload your policy if you haven't been doing that already. So it could be via individual uploads or maybe some global note that your electronic I-9 provider can help out with. All right, let's talk about...
Hey, Dawn. Hey, Dawn, let me just say one thing. I totally agree with you that I think on the remote virtual, one of the big problems is going to be the follow-through. Just as even in very compliant workforces, we always see problems when we're doing audits and doing reviews with Section 3, right? That almost always, even when there are automated alerts and other things, that almost always is a place where companies get into problem. But I would say that I do think the virtual remote poses a little less risk of fraud than this third-party friends and family, right? So I think it's important for employers to think about your workforce and what sort of fraud may be coming into your workforce now based on other unauthorized workers who've lost their job and are trying to get a job kind of at your company. If you allow the friends and family where fraud can be rampant, you really got to have a back end, I would say, real-time review to make sure that the fraud is not become pervasive or something that ICE could look at later as, a pattern of practice and, really negatively affect the company. On the virtual remote, you still have people that are more experienced doing the I-9s versus these friends and family who may have other incentives, while well-meaning, may want to get people who are unauthorized into your workforce.
Julie, those are very good points. And I think it's a perfect segue to move forward into the friends and family or crowdsourced method of I-9 verification. And I know one question that I have received from quite a few members is, really you can have a friend or a family or, your neighbor Ned do your I-9 verification for you. And the other follow-up question to that is, what happens, to your point on this issue of potential fraud in the friends and family method or the third-party method? What happens if that individual that's the third party makes the misrepresentation on the I-9? So as you go through in your presentation, both Dawn and Julie, keep that in mind because that's one question that's on the front of a lot of employers' minds.
Sure. I think that's a really great question. I would just say the individuals who are filling in for Section 2, if it's a one-off, they are unlikely to be the target of an ICE enforcement action or an ICE put in terms of either harboring or inducing illegal employment. But if you had somebody who's the friends and family for a whole community or something else, that kind of person could be someone that ICE would focus on later on. And we've seen that for, union representatives or others, kind of community organizers. So you got to be careful with that. I certainly understand why individuals would be worried about taking on potential liability while signing Section 2, but I don't think that one-offs will ever be an ICE enforcement priority there, absent extraordinary circumstances. But turn it back to you, Dawn.
Yeah, no, so there's a couple things. Let me unpack that. Just in terms of your last comment, I mean, look, at the end of the day, especially in the new Form I-9, USCIS reminded employers that you can use this authorized representative model, but at the end of the day, it's the employer that bears the burden, and it's the employer that will be looked at. So regardless of whether or not somebody made a mistake in taking the wrong documents or they asked the wrong questions, maybe they discriminated against somebody. At the end of the day, the government's going to look to the employer. I do think you're right that that with these very specific, and I have seen those where there's somebody that's working on the whole community and whatever, and ICE may go after those individuals as well. But generally, the guidance here is they're not looking at the third party; they're looking at the employer. So you have to have processes in place. But this kind of goes back to who's allowed to use this policy. This was not meant for individuals that are operating plants right now that have people on site. I mean, it should be very rare that you're using, virtual. There should be company employees on site. Maybe they're not HR, but they should be able to complete the process, and you should be able to do the regular, I'll call it number 4 here. You should be able to do the regular process. This is, something that we should use as a fallback, the virtual. In terms of the third party, basically the third party is stepping into your shoes. We've used third parties in the past for companies that had remote hires, true remote hires. I'm working in Washington, D.C., but I work for a company in California. And, maybe I was supposed to go out there for an orientation, but it doesn't start till next month, or I'm not going to go until next month. So we're going to use these third parties. There are vendors actually that have businesses, and some of them are associated or connected with the electronic I-9 providers where you can actually have these I-9s done remotely. But like I tell our companies, at the end of the day, it's still you. So you have to have a process in place, and you have to be careful about who you choose. So this has always been allowable. The I-9 instructions have allowed for authorized representatives. The timing has never changed. In the past, historically, we used to see notaries being used. There was, networks of notaries. California, however, and Texas don't allow their notaries to complete Form I-9s. But, we saw professionals being asked, people, other attorneys that would complete the I-9. So this is nothing new. But again, we used it in these limited situations. So to kind of repurpose it and use it now, because of social distancing, there just may not be any other choices for individuals. So, you're not going to be able to go to your banker, your lawyer, or notary. Who are you going to use? You're going to use a friend or family. So the questions that we're getting, is it allowable? Yes. It is allowable to use a family member, and it's absolutely, possible. I think that it's reasonable to put some restrictions in place. I would probably want somebody either over the age of 18 or 21 to be completing it. I don't think that, we would want, you probably don't want my 17-year-old, although probably he would do a better job than some individuals. But you want somebody to be, careful, and I don't have the visceral reaction that some people have, when you're saying you're going to have a spouse complete. The key here, the most important thing, if you're using the friends and family model, is to have a secondary check. You have to have your regular HR take a look at these forms. And frankly, maybe it even has to be a higher level, especially if you're in an industry that may be targeted or is known for having an issue with unlawful workers in the workforce. Because as Julie alluded to, the time right now, things are changing. A lot of companies, a lot of industries right now are doing huge rifts. There's layoffs. There are people that have been with one employer for many, many years, maybe even before 1986, and have never had to present I-9 documents, are now going to be moving to other companies and other industries. And for the first time, they're going to be having to complete an I-9, or they're going to have to show new documents. So for inexperienced people, or people who don't know how to, to catch fraud, even, on its surface, having the secondary review is going to be very, very important. And again, as Julie said, a mandatory copy policy is definitely something I recommend. Going to E-Verify, if you're not already on E-Verify, it's something you should certainly discuss with counsel and look at the pros and cons. It is a best practice. It's not perfect. The system is, still fraught with identity theft and other things, but it absolutely is a best practice, and will catch things such as fraud based on individuals presenting any List A documents. So because of the photo match feature in the E-Verify in the E-Verify protocol, whereby an individual presents what we call a List A document. So it could be a U.S. passport or a green card or an employment authorization, anything like that. The government system will actually pop up a photo, and you'll be able to match that photo with the document in front of you. So that's why a lot of employers are interested in using E-Verify. We've gotten a surge of people asking about it right now during this COVID-19 situation. It may not be the time right now to sign up, but certainly something to look at. Julie, do you want to talk about any other considerations for a third party, especially on the privacy side, and how we're logistically going to work these things out?
I mean, I would just say, though, that I think now is the time to sign up for E-Verify if you think you have a high-risk workforce and there's a high potential for unauthorized workers to come into your workforce. I think later on, ICE is going to go back and look at these employers, particularly if unemployment stays high, and E-Verify will weed out some of the most basic fraud that you may have already had in your hires. So if you're doing, friends and family, you're going to want to make sure if you have E-Verify that gives it, some minor level of protection, doesn't shield you from enforcement, but does show you care about this. The other thing, I know we moved to suspended and delayed verification. We're seeing some employers saying we're going to wait until Section 2, until normal business operations resume. I think ICE is not going to find that a doable option in any circumstance. I would encourage you to look hard at options 1 and 2. and think about whether or not those work. I think there could be some extenuating circumstances, but I think they're going to be really rare, and I'm not sure, I'm not sure in a few years that ICE will be as sympathetic to, in not having Section 2 done. So I would strongly encourage not waiving the I-9s at this point.
I absolutely agree with that. Even if it's late, even if you can't do it within the first 3 days, I think it's important to get to it. And you can be a day late, a couple of days late, even in the most serious of situations. There's just got to be a way to get these done. But the example that we gave up here, it's one that certainly I think ICE may understand, but not every company. The majority of my clients are not going to be able to say that this, that their situation rose to the level, of a hospital in the middle of New York City that's experiencing these types of issues. And so, again, you need to really use it frugally and be careful. There should be a way to get this done. So,
Dawn, the one thing that, I'm sorry for interrupting, but the one thing I would add to this is you're also taking a risk because you don't know what the political climate will be like in the future, and with the potential for a long tail liability with regard to these paperwork violations, it's not something that you'd want to risk.
Yeah, they can be expensive. I mean, when we say paperwork violations, anything that's substantive or uncorrected technical violation, they add up. They start, depending if you have a really small percentage of violations in a small workforce, they start off at $230 for a violation, but they go up to $2,292 for violations if you have additional or high percentage in your workforce. And the other thing that I'll throw out there is for individuals that are eventually fined, for companies that are eventually fined for hiring individuals or continuing to employ individuals that are not work authorized, those can be super expensive. For first-time violations, they start off at close to $300 at $573, and they go up to, with the aggravating factors, almost $5,000, $4,856. And if you're in a higher tier, if you've already been audited by ICE, the fines can go up to almost $23,000 per individual. So, that's if you're a large company, those numbers can really add up. So I think it's super important to keep that in mind. Okay, so we talked about this, and then I think the last thing I just want to move on to is the business as usual. The majority of companies in the United States that are operating, that are essential businesses, are operating business as usual in some of their sites. So to the extent that you have people coming in physically, we suggest that you use the model that, is a combination of this number 4, business as usual, get your people in, get them through your regular HR, or combine it with that authorized person, number 2, having an authorized representative try to help. The other thing you can do, again, is layer a third party on top of this. I think it's just going to be a very crazy, very busy time, and there are going to be those shifts in legacy workforces that both Julie and I mentioned, and ICE is going to be looking at this afterwards. So it's worth the time and money to have somebody, take another look at these and make sure that they're completed, not just for the paperwork violations, to make sure that you're actually completing the I-9 first, but that you're not taking fraud documents. And as Julie said, if you're using E-Verify, while certain things can get through, the core things like, fake green cards are not going to make it through the system. So it is important to consider that and keep that in mind. Julie, John, anything else?
No, not on that point. I think you've covered it. Hopefully, we'll all get back to business as usual sooner rather than later, right?
Yeah. So let's talk a little bit, because I know we're getting, questions on. So, what are the exceptions, and are there any exceptions? I know when this guidance first came out, I was very disappointed that the government didn't give a broader exception. But then over the past week, I've spoken to so many companies and other lawyers around the country. And, I did start to see where people were, I'll say, taking a little bit more than the government had wanted to give, and it gave me pause. And Julie and I spoke about it, over the weekend. What's going to happen after all this is said and done, and where are we going to be? Julie, you want to start off with, what do you think those exceptions are, and whether or not, if you have in particular, maybe you're remote in one location, but you have physical people on site, but you're finding it difficult to do the I-9s. What are we recommending?
I think ICE is going to accept, if it's documented, location by location, and understands that, unfortunately, New York is in a different place right now than Kansas. And so businesses may be operating differently. I think what's important to do, if you're doing this location by location, is to make sure everything is fully documented. And that when things start to resume to normal, you're taking immediate steps to remediate or fulfill any of the additional requirements. What's your perspective on that, Dawn?
The same thing. I think documentation and justification is going to be critical. And what I also think is going to drive this later on, at the end of the day, how much fraud we end up seeing, right? So if there are going to be companies that are going to be taking advantage of this, especially, short term, because if you think about it, there's these hiring surges, right? And there are people that are going to be coming to work for maybe a 3, 4, 5 month period of time. By the time, we get back to, or maybe even a 1 month or 2 months, by the time these things are reviewed, and by the time that they're audited, what's it going to look like? Right. So did you have the right processes in place? Did you document it? And were you trying to get around something, or were you acting in good faith? I think these are the things that the government is going to look at. They're reasonable people for the most part, right? When the agents come in, if you have everything written and memorialized, you explain, why you did something, especially why you did something at a certain site versus another site, I'm confident that they will be understanding. But now is not the time to just kind of try to get away with something or do something because it's simple. We've had conversations with companies that, the HR, they're being taxed right now. They're very, very busy, and they don't want to deal with the I-9. So they're thinking that, by doing it virtually or not doing it at all, that they're going to be in a better place. I think that's a big mistake. So I do think it's important to address it and to ensure that it's addressed timely.
And Don, one other thing that you bring up is that when things do resume and ICE starts these again, assuming time has passed, it's really important to have a document retention policy so that if you you're only keeping I-9s for the amount of time that you need to keep them, under law, and you're going through that, I would strongly encourage companies to think about, the document retention requirements and to discard I-9s after that period of time. And that could also be helpful to companies with the surge hiring.
That's right. And and this is something we're struggling with right now, in terms of individuals or we're thinking about right now. We have a lot of legacy workforces, especially in hospitality, that are being either furloughed or laid off or terminated. And while the I-9, may have been acceptable, at the time, maybe now the employers e-verify, or maybe the individual was never I-9. What's going to happen when these people come back and either reapply? Can we use the old I-9 in certain cases based on the retention policies and the ability to use an existing I-9? Maybe. For some of the older employees, probably not, because of the time periods, and I'm not going to bore everyone with the particulars, but these are things that people are going to have to think about. You're going to have to get down in the weeds, and we are going to have to look at that. In terms of retention, like you mentioned, Julie, whenever we can. Whenever we can discard and purge I-9s, we absolutely want our companies to do so. But unfortunately, for whatever reason, a lot of companies are not aware of the I-9 requirements, which again are, for those of you that are unfamiliar, it's for I-9s, 3 years from the date of hire or 1 year from the date of termination. So obviously you would not purge an I-9 for somebody that's active, but these are things that we'll have to think about. All right, let's go on because we're going to get close to trying to discuss the questions that we have from the audience. What do you think it's going to look like? What do you think WorkSite's going to look like when all is said and done? What do you think the White House is thinking right now? And where do you think we're going, Julie?
Well, I think this White House has been pretty cautious with respect to worksite enforcement over the past couple of years. We have not seen as much of a surge as we would have anticipated, although they still have had a number of audits which kind of dragged on. I think, however, if unemployment goes through the roof and it's sustained, I think there will be a lot of pressure for the agency from Congress and from the White House to start really ramping up worksite enforcement. To make sure that these jobs are preserved for Americans and other authorized workers, and that they will look to see, can they bring criminal cases? They will look to see were people abusing the guidance, and that will be the focus. But I think a lot depends on how quickly the country recovers. If we recover, somewhat sharply and quickly, and unemployment is lowered, I think there could be less focus. But if we have a sustained period of higher unemployment, I think I think there'll be more pressure, and I think there'll be more cases in this area. Right now, many of the ICE agents who used to do worksite enforcement may be focused on other things. There is a possibility that ICE agents will be detailed to work on things related to COVID-19 support and recovery, but when this is over, they're going to be focusing back on those numbers again. I don't know what you think, Dawn, but that's kind of how I see it.
Absolutely. I totally agree with you. Right now, just so everyone is aware, ICE actually began another surge of notices of inspection, the I-9 audits. They started at the beginning of March. So many companies across the United States received a notice of inspection. And that's because that was their directive. Worksite enforcement, Homeland Security investigations was told, even at the beginning of this, basically business as usual from what we're hearing. So they went ahead and they served these NOIs. Some companies responded. The majority of those of companies that received the NOI were in the process of trying to collect information in the middle of this COVID crisis. So what happened when this guidance went out, there was also a moratorium on notices of inspection. Headquarters was told no more NOIs, and for those individuals that were companies that were served, there's actually a 60-day extension. So companies were relieved that in the middle of this crisis, they also didn't have to respond to the notices of inspection, because what happens when you get an NOI, you generally have 3 days in which to produce your I-9s, although sometimes you can get an extension of that time. And in addition to the I-9s, ICE usually asks for a laundry list of other things. So the good news is that was put on hold. I know that the agents were told to kind of go back and to clean up all the backlog that they have, because there has been this huge increase. But I do agree. I don't think that this administration plans to let up on worksite, and I think depending upon how the economy recovers and how quickly will really depend upon what the focus is. But it'll be incumbent upon employers to ensure that they review their I-9s and review what was done after the crisis passes and things stabilize to the extent that they can stabilize. So worksite enforcement is still going to be a priority as far as I can see. Criminal enforcement, I think also companies need to consider. There's been no moratorium. The guidance has been if it's a criminal case, go forward on that. But like Julie said, there are details. There are agents that are already detailed other things. So it will be it'll be interesting to see what else happens. Unfortunately, I do think that there's going to be a lot of fraud that comes out of this. So, Julie, do you think that ICE is going to be making cases now or later on the criminal side?
I think probably later, although if there's something that's really egregious, they could be following up on it now. But, there's a long memory, long statute of limitations, and if they get in and start a criminal case, it can make a company's life miserable for years, even as at the end of the day, it just results in a civil fine. So it's really important for companies to be thinking about how they can avoid fraud now. And I think if they weren't on E-Verify and they think that they're at a high risk for fraud, now, in my view, now's the time to join as a first step towards showing ICE that you're serious about compliance.
Great. So, John, do you want to do the CLE code? I know some individuals are waiting for that.
Yes. For those, get your pen ready if you are not at your computer, but the code is SS, as in Seyfarth Shaw, 1109. That is SS 1109. And with that, let's move forward to questions. I don't know how we want to go about doing this, but
I'll start, and we can maybe just come. Are we taking any live, or we're just going to go through what we have in our paper? I think we have enough that we probably can start. So, okay, no, so we're not going to do live. Perfect. All right, so I got a good question. What happens if we have a new hire and we use the remote virtual option, but the individual leaves the company before the national emergency ends and you can't physically confirm their ID? I would notate, memorialize everything. Put a note, when you move it to your terminated binder, go ahead and make a note there. There's really nothing else that you can do on that. I don't know if anyone wants to start grabbing those, the questions. We can try to go through them, like speed dating. All right, I'll take another one. If we still have some people working out of our office, but those people do not complete I-9s, would we still qualify as remote I-9s? I think that's the crux of the question. To the extent if you have, if your office is operational, I do think that you would want to try to get the I-9s done in person. However, I know in my office we have literally just essential people coming in for 1 or 2 hours a day, to pull, maybe to do a government filing with CIS, to pull a piece of mail and scan it. Generally, we are not open for business. I would consider us to be closed, and certainly, to be able to use the remote or the authorized agent if we were still onboarding anyone. Very different, though, than other, larger companies that may have a full staff. If you have security people on site, or you have just, maintenance, and, I would not consider that to be open. Julie, John, anything else on that?
No, I agree with that. I think it'd be hard pressed for ICE to bring an enforcement action based on that piece. So I think as a practical matter, the risk is fairly low. Also had a question here about a notice from DHS that said 60 days from the date of notice for checking documents in person, and what if national emergency doesn't end until after that date? I think we could expect that, first of all, I think it said when the national emergency ends, but I think we also could expect ICE to update the guidance based on, as necessary, to include, the full period within a national emergency, if necessary. But I don't think it is necessary, actually. I think there's an or there.
Right, and they said, I think, it's whichever comes first. But no, I agree on that. Another good question. Go ahead.
Just one thing to add on that is if the situation, heaven forbid, gets worse, I also would see that ICE and USCIS and DHS would update the guidance accordingly, that if you see more and more companies staying closed, they will extend that time period. Another question that I have is that if your company is required to find an authorized representative to do the I-9 verification, are there any best practices or recommendations that you're advising people to do to go about maintaining health and safety requirements as an employer? Any liability the employer must, worry about if they're using an authorized representative to do this?
Well, I think that's why we're calling it the friends and family right now, right? That's why we're not saying go out and, find a notary, whatever. I think it's whoever you are sheltering with, whoever is in your household, and you are already, you're already with. I would not, and in our guidance that we're writing, we are reminding, people about that. I had seen something come across my desk the other day where there was all these things that the employer wanted the authorized agent to sign off on, absolving them of any liability. I'm not sure that someone who's doing you a favor, how much they're going to sign or what they're going to look at. So I do think, you need to be reasonable in these times. The policy, a remote policy or an authorized agent policy today under COVID would be different than an authorized agent policy that you might have had before or that you'll have after. This is really a special scenario. So I do have a question. I think it's a good question. What if employee doesn't have access to their original documents due to being sheltered in with documents at another residence? Julie, what do you think ICE will say about that?
I think that hopefully that's a very rare scenario, but I think it could happen. I think in that instance, the employer should use kind of best judgment. First of all, see if there's a way to get access to the documents. Were documents left where no one can access them? Are there any things that are available online or other things? I would then document and notate what you have and move and then update that as quickly as possible. I think if it's a one-off, I think that would be okay. I think if there are multiple people doing that, then it starts to look like a fraud pattern. That would be my view because I think ICE does and the government does want people to be employed, and this is such an extraordinary time.
Yeah, absolutely. And I think that there was a follow-up question on that. Assuming that the person was actually coming in and presenting the documents, could they accept the documents temporarily, copies of the documents temporarily? And I think the answer probably is yes. That's exactly what you were asking for. If we could get those, those kind of documents. So I think it's important. And then I think we're going to take one last question about talking more about the secondary review and how can employers do this. In terms of the secondary review, I would say, have your subject matter experts take a look at those secondary reviews. I know that many of our clients are sending us, can you take a look at this document? I have a concern. Julie Shop, her consulting firm, are doing secondary reviews on all documents for certain companies, sometimes even in real time. So that's what we mean by a secondary review, having someone else take a look at the documents, especially if you have inexperienced HR that are coming on for a hiring surge. All right,
Dawn,
go ahead.
One last question that I have from another company of ours is that for SSA closing, and they have workers that are coming on, they want to use a Social Security card, but all they have is the receipt that SSA has received their application for a card. Is that sufficient for one of the documents to use during this period of time, or is that still, or do you envision that company needing to go about finding other documents from that person? Because if that's what they're offering, you can't say you have to say this is unacceptable, correct? So it's not one of the listed documents.
Right. So if it's a document for someone who's first applying for a card, then no, it would not be a receipt. We're getting a lot of questions about E-Verify and the use of Social Security cards. So E-Verify has said, they absolutely understand that Social Security is closed and, the government offices are closed. But if you're asking whether or not somebody can use a receipt for an application as a lessee document, the answer is no. If you're asking whether or not somebody can still work that perhaps is an E-Verify employer and not have their Social Security card yet, the answer is yes. So E-Verify employers are mandated to have a Social Security number, to have their employees complete a Social Security number in Section 1, but that's okay, for now. What always is, you would just basically say that the Social Security card is delayed. So I think in that case, to your question, the answer is that would not be an acceptable List C document.
Thank you, Dawn. We are over time by 5 minutes. I want to thank you, Dawn, and you, Julie, for taking the time out of your day to do this webinar. I also want to thank all the folks that are still with us on this call for sticking with us to the last hour and 20 minutes. If you have any further inquiries that you want to make, I'm going to put up the Seyfarth website and the Chamber's website that has all sorts of resources that you can turn to if you need them. Julie, Dawn, I'm going to let you both have the floor one last time. If there's anything else you want to add with.
Sure, Dawn. Thank you so much, and thanks to everyone. We see that there are a number of questions that we didn't get to. We love having all the questions. I think it shows, hopefully, that people are still hiring. We'll take a look at the questions. I think they're going to send the information so we can get back to you guys individually. You can also feel free to contact me or anyone on my team at the website is guidepostsolutions.com. Julie J. Wood at guidepostsolutions.com, and would love to help you if we can in any way.
Thank you, Julie, and thank you, John. This has been a very quick hour and 20 minutes. As Julie said, we'll go ahead and answer as many questions as we can post-webinar. I would say to everyone, just be careful out there. Be reasonable. The government will be reasonable. Document, document, document. Think about what is going to be best for you long-term, not in the easiest short-term solution. But that said, these are trying and really unprecedented times. Stay healthy, stay safe, and thank you for participating.
This concludes today's webinar. Thank you for attending.